This is the brief on the Philippine Supreme Court ruling on public assemblies. This landmark 2006 decision, Bayan v. Ermita, settles the ultimate tug-of-war between the government's need for public order and your absolute constitutional right to protest. First, let's look at the baseline rule. The court upheld the Public Assembly Act, meaning you do need a permit for public spaces. But it's totally content neutral. It only regulates the time, place, and manner, not your message. Think of it like booking a public community center. The city just manages the schedule and traffic. They literally aren't allowed to judge or censor your event's theme. Second, let's talk police overreach. The police tried bending these rules using a policy called Calibrated Preemptive Response, or CPR. Well, the court struck CPR down completely because the law strictly demands maximum tolerance. That's the highest degree of police restraint, forbidding firearms and tear gas unless there's actual violence. Seriously, if the law already demands maximum tolerance, why invent a shadowy new term like CPR, unless the goal was to sneakily bypass those exact limits? Finally, we get to the ultimate safeguard. To ensure permits aren't used to permanently silence people, the court ordered cities to designate specific freedom parks, where no permits are needed at all within 30 days. And here's the brilliant legal trap. If local mayors fail to pick a specific park within 30 days, every single public park in that city automatically becomes a permit-free free speech zone. So, while the government is allowed to manage traffic and public safety, it absolutely cannot preemptively silence the voice of the people.
Welcome to The Explainer. Today, we're talking about your rights. What can you actually do when you join a protest in the Philippines? We're about to break down a crucial Supreme Court decision that spells out the rules of the game, drawing a very clear line on how, when, and where you can make your voice heard. You know, for over a century, the Supreme Court has warned that this right to protest could easily become a delusion and a snare. Basically, an empty promise. A trap. And the case we're diving into today is where that warning was seriously put to the test. So our story kicks off back in 2005. Tensions were high, protests were happening on the streets of Manila, and they were often met with force. This clash lit the fuse on a legal battle that went all the way to the highest court in the land. So you had groups like Bayan and the Kilusang Mayo Uno holding these big rallies. But they reported that police were breaking them up, sometimes violently, leading to people getting hurt and arrested. They argued, hey, our constitutional right to peacefully assemble is being violated, and they decided to take that fight to the Supreme Court. Okay, so to really get what's going on here, you have to understand the two conflicting ideas at the center of it all. You had a law that had been around for decades, and then this brand new government policy that seemed to say the complete opposite. First up, we've got the official definition of a protest from a 1985 law called the Public Assembly Act. As you can see, it's pretty broad. It covers pretty much any kind of gathering in a public space to get a point across. But then, in 2005, the government rolled out this new policy with a very different vibe. Calibrated Preemptive Response, or CPR. This basically gave police the power to be proactive, to step in and disperse a crowd to prevent chaos before anything even happened. But here's the thing, that 1985 law already had a very specific rule for how police should act. It's called maximum tolerance, and it legally requires the exact opposite of being preemptive. It demands the highest degree of restraint. And there you have it, the heart of the conflict. On one side, the law says, hold back, show restraint. On the other, this new policy says, jump in early. You can see how this massive contradiction was causing chaos on the ground, and why it was destined for a legal showdown. So let's head into the courtroom. This is really a classic constitutional debate, right? It's the people's fundamental rights up against the government's duty to keep things orderly and safe. So the protesters argued that the whole permit system was an illegal prior restraint, basically censorship before you can even speak. And that new CPR policy, they said it was a totally unconstitutional power grab. The government, of course, pushed back. They said, look, the law isn't about your message, it's just about logistics, time, place, and manner, and CPR is just a tool to help us keep the peace. So, with these two powerful forces clashing, how did the Supreme Court settle it? What wins out? The state's need for order or the people's right to be heard? Well, the court handed down an absolutely landmark decision. They drew a really clear line in the sand, spelling out exactly what counts as a legal regulation versus what is an illegal restriction on freedom. First things first, the The court looked at the protest law itself, Batas Pambansa 880, and said, yep, this is constitutional. Requiring a permit is, in itself, perfectly legal. And the reason why is fascinating. The court called the law content neutral. What does that mean? It means the government can't regulate the message. They can't stop a protest because they don't like what you're saying. But they can regulate the logistics, the time, the place, and the manner, just to make sure things stay orderly. But, and this is a huge but, the court then turned to the government's Calibrated Preemptive Response policy and declared it null and void, totally illegal, gone. And this slide really says it all. The court found that CPR just sowed confusion and was used to justify abuses. So they made it crystal clear. The one and only legal standard for police at protests is maximum tolerance. End of story. So what does this all boil down to for you, the average citizen? Well, the court didn't just issue a verdict, it basically gave us a handbook on our rights. So let's break down what you need to know. Now, this is a total game changer. The court put a spotlight on this incredibly powerful rule that was already in the law. If you apply for a permit and the mayor's office just doesn't get back to you within 2 working days, guess what? Your permit is automatically considered granted. You are legally good to go. The ruling also hammered home these really specific rules for police. They have to stay 100 meters away, they cannot carry firearms, they can only use force like tear gas if there is actual violence breaking out, and this is so important, a few troublemakers in a crowd cannot be used as an excuse to break up an entire peaceful assembly. You know, while reviewing this whole case, the court noticed that a really important part of that 1985 law had been pretty much ignored for over 20 years. So they put their foot down and gave every single city and municipality in the country a strict deadline, 30 days. And here was the ultimatum. Every local government had 30 days to designate an official freedom park, a place where you could protest without needing a permit at all. And if they failed to do it, the court ruled that every single public park and plaza in that city would automatically become a freedom park. Incredible, right? And that's our explainer. The Supreme Court drew a very clear line, getting rid of a confusing policy and reinforcing the powerful protections of maximum tolerance. It leaves us with a pretty big question, though. A right is one thing on paper, but if citizens don't actually know it exists, how powerful is it really?
Imagine you are marching down the street and you are just absolutely furious at the government.
Right. You're at a total boiling point.
Exactly. It feels like this massive historical turning point for your country, you know? And you feel this deep, undeniable moral obligation to just get out there, to take to the streets to protest.
You have to make your voice heard.
So you gather, you march, you're raising your voices, but suddenly, bam, a solid wall of riot police completely blocks your path.
Just shutting down the whole route.
Yeah. And their excuse. They tell you that you are blocking major intersections. They say you are disrupting the daily commute of like tens of thousands of people, and you are literally freezing the local economy.
Which, to be fair, a massive crowd does do.
Right. But today, we are asking the ultimate democratic question here. Who wins? Your sacred constitutional right to protest or a commuter's everyday right to simply beat traffic and get to work on time?
It really is the ultimate civic tightrope walk. I mean, you have the right to speak, but does that include the right to stop an ambulance?
Oh, wow, yeah. That's a great point.
And you have the right to public order, sure, but does that include the government's right to silence dissent just because it causes a traffic jam?
Right.
These are not just, abstract philosophical debates that live in some dusty constitutional law textbook. They are physical, logistical nightmares that had to be managed on actual asphalt.
In real time.
Exactly. In real time, often with incredibly high stakes.
Okay, let's unpack this, because today's mission on this deep dive is to explore one of the most fascinating blueprints for navigating this exact street-level conflict.
It's a really incredible case study.
It is. We are going to unpack a monumental 2006 Supreme Court ruling from the Philippines. The case is called Bayan versus Ermita.
Such a landmark decision.
Totally. But we are not just looking at the court decision in isolation, right? We are pairing it with the actual raw text of the law that the court was scrutinizing.
Which is so important for context.
Yeah. That law is Batas Pambansa Bilang 880, widely known as the Public Assembly Act of 1985.
And setting the stage for you, the listener, is just super crucial here. We are looking at the unfiltered text of a national law and a major judicial decision. The sources we have in front of us detail some incredibly tense, highly politically charged clashes between activist groups and government authorities.
And we should clarify, we are not taking sides here.
Right. Our role here is absolutely not to take sides in those historical political disputes.
No.
We are not evaluating the righteousness of the protesters' cause or, the political maneuvering of the administration. That's not what this is about.
Right. Our goal is to impartially break down the fascinating legal frameworks, the history of how these specific rules came to be, and the ultimate judicial resolution that was handed down.
Exactly. We are keeping our focus strictly within the four corners of these source documents to really understand the universal mechanics of democracy.
Yeah, because to really understand those mechanics, we can't just look at the law in a vacuum.
You really can't.
We have to start with the inciting incidents. We have to look at what was actually happening on the ground that forced the Supreme Court to step in and parse this law line by line.
Which gets pretty intense.
Very. So take us back to the Philippines in late 2005. What was the reality on the streets?
Well, the picture painted by the petitions filed with the Supreme Court, it shows a period of intense, widespread public unrest. We're looking specifically at the months of September and October in 2005.
Okay, so a really concentrated period.
Very concentrated. And the court ended up consolidating petitions from 3 distinct groups of citizens and organizations.
Right.
And understanding who these groups are really gives us a sense of the sheer scale of the unrest. First, you had a group including organizations like Bayan, Karapatan, and the Kilusang Magbubukid ng Pilipinas.
And these are cause-oriented, often massive grassroots organizations, right?
Exactly.
Which means they have the logistical capability to mobilize thousands of people from different sectors all at once, like farmers, human rights advocates, students.
Precisely the point. They can pull massive crowds. Yeah. Then you had a second group of 26 individual petitioners led by a citizen named Jess Del Prado. And finally, a third group led by the labor center Kilusang Mayo Uno, or KMU, along with the National Federation of Labor Unions.
That third group is a massive detail.
Oh, absolutely.
When a national labor center mobilizes, that is not a casual weekend gathering.
Not at all.
These are organizations composed of thousands of hardened workers mobilizing for economic survival. When they take to the streets, it represents a significant portion of the workforce literally pausing their labor to make a point.
Yeah, the scale is massive. And they were attempting to hold these large-scale mass actions and rallies at some of the most prominent high-traffic locations in the capital region.
Like where?
The sources specifically mention places like the Mendiola Bridge.
Oh, wow.
Yeah. For context, Mendiola is historically a highly contested, highly symbolic protest site.
Because of its proximity to the presidential palace.
Exactly. It's right near Malacanang Palace, the official residence of the president. They were also marching on España Avenue.
Which is huge.
It's a massive multi-lane traffic artery right in front of the University of Santo Tomas.
So we have thousands of people, highly organized, converging on the most sensitive political and economic choke points in the city.
A recipe for major tension.
Right. So what happened when they actually got there?
The conflict detailed in the court documents is stark and violent. On specific dates, September 26th, and then a series of consecutive days on October 4th, 5th, and 6th, these petitioners alleged that their marches and rallies were physically blocked by heavily armed police forces.
It's completely walled off.
Yeah. But the police didn't just hold a line. The petitioners claimed they were forcibly dispersed.
Oh, man.
The documents detail that protesters were arrested and several individuals actually suffered physical injuries during these dispersals.
And why were they marching in the first place?
The protesters argued they were marching for a very specific, urgent reason. They claimed the government issuances at the time were effectively putting the country under an undeclared martial rule.
Wow. That is the heaviest accusation a citizen can level at a democratic government.
It really is.
But the police on the ground, the ones actually holding the shields and making the arrests, they don't operate in a vacuum.
Right, they follow orders.
Exactly. They are operating under a specific top-down directive. And this brings us to a crucial piece of the puzzle introduced by the government.
The CPR policy.
Yes. On September 21st, 2005, Malacanang issued a press release announcing a brand new policy. They called it Calibrated Preemptive Response, or CPR.
And the introduction of CPR is the true flashpoint of this entire constitutional crisis.
Why is that?
Because prior to this press release, the standard operating procedure for law enforcement dealing with protests was a policy embedded in the 1985 law known as maximum tolerance.
Maximum tolerance. That sounds pretty straightforward.
It was. The public understanding of maximum tolerance was that police were supposed to exercise the absolute utmost physical and operational restraint. But with this single press release, the executive branch announced that CPR was now the rule of the land, enforced in lieu of maximum tolerance.
See, that is entirely unplayable for the citizens on the street.
It's so confusing.
It's like, okay, think of it like being in the fourth quarter of a championship basketball game.
I love a sports analogy.
Right. Both teams have been playing all season under a very specific set of rules regarding what constitutes a physical foul.
Everyone knows the threshold.
Exactly. You know how hard you can push. But right in the middle of the final game, the referee suddenly steps onto the court, blows the whistle, and announces, actually, we are replacing the old foul rules with a new system called Calibrated Preemptive Response.
Chaos.
Complete chaos. Suddenly, the players have no idea what they are allowed to do. Is a slight bump now a foul? Can they still defend aggressively?
They're flying blind.
Yeah. The rules of the game have been changed right in the middle of the action, leaving everyone on the floor utterly confused and, frankly, vulnerable to arbitrary penalties.
That is a perfect way to look at it. The protesters felt the rules had suddenly been rigged to suppress them before they even committed an infraction.
Just based on the name alone.
Yeah, I mean, the phrase preemptive response itself is an oxymoron that terrified civil liberties advocates. How do you respond to something that hasn't happened yet?
You really can't. It sounds like pre-crime.
Exactly.
Yeah.
Now, the government, on the other hand, argued they were just trying to maintain order in a city on the brink of paralysis.
Which is a valid concern for a city manager.
Sure. But this on-the-ground chaos, this physical clash between protesters invoking their rights and police invoking CPR, it forces us to step back.
We have to ask what the original rules were.
Right. What were the original rules of the game supposed to be? And that leads us to the text of the 1985 law governing these public assemblies. Batas Pambansa number 880.
Okay, so we have to open up the rule book. Batas Pambansa number 880, or BP 880. The full title is An Act Ensuring the Free Exercise by the People of Their Right, Peaceably, to Assemble and Petition the Government for Other Purposes.
A very grand title.
It is. And it was approved on October 2010, 1985. The historical context here is just unavoidable.
Absolutely vital.
Late 1985 in the Philippines was a pressure cooker. It was just months before the EDSA People Power Revolution.
The streets were already boiling with unrest.
Exactly. This law was born out of an extreme tension between a government trying to maintain control and a populace demanding to be heard.
Yeah.
So how did they define the boundaries? When the law says it regulates a public assembly, what exactly are the parameters?
Well, the architects of the law were very careful with their definitions. If we look at the text, it gives a highly specific legal definition.
Okay.
It states that a public assembly means any rally, demonstration, march, parade, procession, or any other form of mass or concerted action held in a public place.
So any big group outside.
Well, not just any group. It's not just about the physical gathering. It is entirely about the intent of the gathering. The law specifically lists those intents. Presenting a lawful cause, expressing an opinion to the general public on a particular issue, protesting or influencing any state of affairs, whether political, economic, or social.
Or petitioning the government for redress of grievances.
Exactly.
Which means the law is inherently focused on civic and political expression. So if a massive crowd gathers in a public park to watch, I don't know, a fireworks display or to attend a massive outdoor food festival, that does not fall under this definition.
Not at all.
Because they're not protesting, petitioning, or trying to influence a state of affairs.
Right. But, and here's the catch, if those same people suddenly unfurl banners complaining about food tax rates and start chanting at City Hall, they instantly transform.
Wow.
Yeah, they instantly transform into a public assembly governed by BP 880.
The transformation is based purely on the introduction of a political or social grievance.
Exactly. It's the message that triggers the law.
Yeah.
And what is equally crucial is understanding what the law specifically carved out and excluded from this definition.
What did they leave out?
The law explicitly states that picketing and concerted actions by workers in strike areas resulting from a labor dispute are not covered by BP 880.
Oh, that makes sense. Because a labor strike is a completely different mechanism of action.
How so?
Well, a strike isn't just about expressing an opinion. It is a strategic economic blockade. It's a negotiation tactic governed by the Labor Code, which has its own entirely different set of rules for mediation, arbitration, and lawful picketing zones.
Exactly the distinction the legislature was making. It's an economic tool, not just a civic one.
Right.
Similarly, the law excludes political meetings or rallies held during an official election campaign period.
Because those are about getting votes.
Right. The Omnibus Election Code governs those.
Yeah.
Those rallies are about securing votes within a designated time frame, which carries completely different logistical and regulatory needs.
Are there any other exceptions?
Yes. Finally, if you hold an event on the campus of a government-owned educational institution, that is subject to the specific rules and academic freedom guidelines of that school.
So the law is essentially admitting that it is a highly specialized tool.
Very specialized.
It is not a blanket ban on crowds. It is a surgical regulation specifically for political and social protests in public spaces.
Exactly.
So if we know what a public assembly is, how does a city actually prepare for, say, 10,000 angry people showing up on a Tuesday? They couldn't just guess, right?
Right. They need data, which is why they engineered this highly contested permit system.
Tell me about the permit system.
The permit system is really the beating heart of the controversy. The core rule of BP 880 is that a written permit is required for any person to organize and hold a public assembly in a public place.
Okay, so you have to ask permission.
Yes. And the application process is rigorous. The application has to be in writing. It must include the names of the leaders, the specific purpose of the assembly, the date, time, and duration.
I want all the details.
All of them. It demands the exact places or streets to be used, the probable number of people attending, and even the transport and public address systems that will be utilized.
They want a full logistical blueprint.
They do. And the most contentious part is the timeline. This detailed application must be filed with the office of the city or municipal mayor at least 5 working days before the scheduled assembly.
Okay, wait. I have to push back on this on behalf of anyone listening who watches the news cycle.
Go for it.
If a massive, outrageous political scandal breaks today, say, a blatant act of corruption is exposed on a Monday morning.
Sure.
The public is furious. People want to hit the streets immediately to voice their collective anger. The momentum is visceral.
It's an emotional reaction.
Exactly. If a citizen has to sit down, draft a logistical blueprint, submit it to the mayor's office, and then wait 5 working days to get a piece of paper validating their right to be angry, doesn't that completely suffocate the spontaneity of a public outcry?
It definitely slows things down.
By the time a week passes, the news cycle has moved on. The urgency is entirely diluted.
The tension you are highlighting is exactly what the petitioners argued before the Supreme Court.
I can see why.
It is the fundamental friction between the ideal of spontaneous, unfiltered free expression and the state's absolute necessity to maintain public order and safety.
Right.
The government's counter-argument, which is embedded right in the rationale of the law, is that a city is a fragile ecosystem.
That's a good way to put it.
If 50,000 people are going to occupy a major public highway or a vital intersection for an appreciable length of time, the local government absolutely needs that advance notice.
Because they have to manage the fallout.
Exactly. They needed to designate alternative routes, reroute massive volumes of vehicular traffic, deploy emergency medical services.
Make sure fire trucks can get through.
Yes, and prevent what the law terms grave public inconvenience and serious or undue interference with the free flow of commerce and trade.
So it is the brutal logistics of urban survival versus the passions of the citizens.
That's the clash.
But let's say I play by the rules. I file my permit 5 days in advance, detailing my route and my numbers. Does the mayor just have absolute veto power?
What do you mean?
Like, can a mayor sit behind their desk, look at my application, see that I am protesting a policy they personally authored, and simply say, denied?
Well, the architects of BP 880 anticipated that exact potential for abuse.
Okay, good.
The law includes critical safeguards to prevent the mayor from acting as an arbitrary dictator of speech.
How does it do that?
First, the mayor only has 2 working days to act on the application.
Only 2 days.
2 working days. And if the mayor does nothing, if they try to suppress the protest through bureaucratic paralysis by simply sitting on the application, the permit is legally deemed granted by default.
Wow, that is a fascinating mechanism. Silence from the state equals permission for the citizen?
Isn't that interesting? It forces the government to act efficiently or completely lose their regulatory power.
I love that.
Furthermore, the standard for actually denying the permit is exceptionally high.
What's the standard?
The law states it is the duty of the mayor to grant the permit unless there is clear and convincing evidence that the public assembly will create a clear and present danger to public order, public safety, public convenience, public morals, or public health.
Clear and convincing evidence of a clear and present danger. We need to unpack that standard because those are not just buzzwords.
No, they have deep legal meaning.
Right. In the law, clear and convincing evidence is a massive hurdle. It means the mayor cannot just have a hunch that things might get out of hand.
I can't just guess.
No, they cannot rely on rumors or a general feeling of unease. They need documented, highly probable proof of an imminent threat.
And what about clear and present danger?
That is a standard that traces all the way back to American jurisprudence, to Justice Oliver Wendell Holmes. It means the danger must be right now, immediate, and catastrophic.
Exactly. The mayor bears a really heavy burden of proof to justify silencing the assembly.
Okay, so there are safeguards.
Yes. And yet, despite these written safeguards, the strictness of this permit system, especially the fundamental requirement to ask the government for permission to speak in the first place, is exactly what the arrested protesters took to the Supreme Court.
Because they felt they shouldn't have to ask at all.
Exactly. They argued that the requirement to get a permit at all made the law itself fundamentally, irreparably unconstitutional.
And this brings us to the core constitutional battleground of Bayan versus Ermita.
The petitioners launched a massive multi-pronged attack against BP 880. Their primary legal weapon was the argument that the law is content-based.
Okay, content-based. Now, to understand why that matters, we have to look at constitutional law.
Break it down for us.
If a government regulation restricts speech based on the actual message, the ideology, or the content of that speech, it commits the ultimate constitutional sin.
It's a huge red flag.
Huge. It is subject to the strictest possible judicial scrutiny and is almost always struck down because you cannot let a government official play film critic with a protest, deciding which messages get a green light and which get banned.
Right.
So the petitioners argued that BP 880, despite looking neutral on its face, secretly targets anti-government dissent.
And the petitioners built a fascinating linguistic argument to prove this.
Oh, like looking at the specific words.
Yes. They pointed to the specific vocabulary used throughout the 1985 law. They pointed to the definition of a public assembly requiring a lawful cause, or expressing an opinion, or protesting, or influencing.
Okay, how does that prove it's content-based?
The petitioners argued these specific words suggest the exposition of a cause that is not espoused by the incumbent government.
I see.
They also targeted the very term maximum tolerance.
Why target that? It sounds like a good thing.
Their logic was really sharp here. They said, in human behavior, you only tolerate things you inherently dislike or disagree with.
Oh, wow. That is clever.
Right. Therefore, by mandating that police tolerate the assemblies, the law reveals its true nature. It is designed specifically to regulate, manage, and ultimately suppress anti-government assemblies, making it a content-based restriction.
It is a brilliant deconstruction of the language. I mean, if I have to ask the government for a permit and the government's official stance is that they will tolerate my presence, it feels like a stacked deck.
It feels biased.
It feels like a prior restraint on an absolute constitutional right.
So how did the respondents, the executive secretary, the police chiefs, the mayor of Manila, defend the law against that linguistic attack?
The government mounted a robust defense, grounded in the practicalities of governance. They countered that BP 880 is completely content neutral.
Content neutral.
Yes, they argued that the law, as written and intended, does not care what your protest signs say.
Okay.
It does not care if you are marching to praise the president or marching to demand the president's resignation. The regulatory mechanism is supposedly blind to the message. The law only regulates the time, place, and manner of the assembly. Time, place, and manner. The holy trinity of content-neutral regulation.
Exactly. The government argued that mayors absolutely need this power not to silence dissent, but to prevent catastrophic physical disruptions to city life.
The logistics argument again?
Always. Their argument was utilitarian. If 50,000 people suddenly block a major economic artery on a Tuesday morning without any prior coordination, it is not just an inconvenience.
It's an emergency.
It paralyzes a city's economy, it traps citizens, and it endangers public safety if fire trucks and ambulances cannot navigate the gridlock.
What's fascinating here is how the Philippine Supreme Court resolved this fundamental, seemingly intractable clash between the right to speak and the right to a functioning city.
How did they do it?
To navigate this, they did not just look at Philippine law, they leaned heavily on established international jurisprudence, diving deep into major American Supreme Court cases to find a guiding philosophy.
That's super interesting. Yeah, which cases?
The court extensively cited cases like Hague versus CIO and Cox versus New Hampshire.
Okay, let's talk about Hague versus CIO.
It's a landmark 1939 American case, and it is particularly vital here. In that case, a mayor in New Jersey tried to use city ordinances to prevent labor organizers from holding public meetings in the streets and parks.
Trying to shut them out of public spaces.
Exactly, but the U.S. Supreme Court struck that down. And in doing so, they articulated a profound concept about public space.
What was the concept?
The foundational principle the Philippine court drew from Hague is that streets and public parks have immemorially been held in trust for the use of the public.
Held in trust?
Yes. Time out of mind, they have been used for the purposes of assembly, communicating thoughts between citizens, and discussing public questions.
That is a really powerful framing.
It is. It means the government does not own the streets like a private landlord. The streets belong to the people, held in trust by the state, specifically for the purpose of the people talking to each other.
This sounds like a massive victory for the protesters' argument.
It is a huge validation of the right. But, and this is key, the legal doctrine has a second, equally important half.
There's always a catch.
Always. The courts in both Hague and Cox established that while the privilege of a citizen to use the streets and parks for communication is an inherent right, it is not an absolute unrestrained right.
Okay.
It must be exercised in subordination to the general comfort and convenience of the whole population and in consonance with peace and good order.
So you can't just do whatever you want.
Right. A citizen cannot simply hijack a public intersection permanently. The state cannot, in the guise of regulation, abridge or deny the right to speak, but it absolutely can and must regulate the physical footprint of that speech to ensure society continues to function.
Okay, if I'm translating this legal philosophy into everyday reality, the law is basically acting like a traffic cop at a notoriously busy, dangerous intersection.
I like that, traffic cop.
Right. The traffic cop standing in the middle of the road does not care what the bumper sticker on your car says.
Not at all.
You could have a bumper sticker praising the mayor or a massive decal demanding the mayor be thrown in jail. The cop does not read the content.
Because it's irrelevant to their job.
Exactly. The cop's only job is to look at the physical realities of the intersection. They regulate the time, place, and manner of your movement.
Yeah.
They tell you when to stop and when to go, not to suppress your bumper sticker's message, but to ensure that your car does not cause a massive multi-vehicle pileup that stops everyone else from moving.
That traffic cop analogy perfectly captures the Supreme Court's ultimate distinction.
It really clarifies it.
It does. And using that logic, the court handed down its verdict and firmly upheld the constitutionality of BP 880.
So the law survived.
It did. They ruled that the permit system is not an absolute ban on speech, but merely a necessary regulation of time, place, and manner.
They systematically dismantled the petitioner's arguments then.
Completely. They rejected the idea that the law was vague. To prove their point, they literally cited Webster's dictionary to establish that the word public has a clear, universally understood meaning.
Pulling out the dictionary. Wow.
Yeah. Furthermore, they ruled that the standard delegated to the mayors, the requirement to find clear and convincing evidence of a clear and present danger, was mathematically precise enough to prevent mayors from issuing arbitrary, politically motivated denials.
So the highest court in the land declares that the 1985 permit system is valid.
Yes.
The original rules of the game are constitutional. The traffic cop is allowed to direct traffic.
Exactly.
But wait, that brings us crashing back to the reality of the streets in late 2005.
Oh, right.
If BP 80 is the supreme law, what about that press release from Malacanang? What about the calibrated preemptive response that police were using to aggressively disperse people, changing the rules mid-game?
This tension leads us to the spectacular demise of the CPR policy.
And the unraveling CPR is where the source documents reveal a truly dramatic, almost cinematic plot twist.
Where did this happen?
It occurred right in the middle of the oral arguments before the Supreme Court.
Oh, wow. In the courtroom.
Yes. The justices are sitting on bank, grilling the lawyers representing the government about the legal foundation of this calibrated preemptive response.
I can imagine the pressure.
And under the intense heat of judicial questioning, the Solicitor General, the chief lawyer, tasked with defending the government's actions, completely backtracks on the policy.
He was folds. Right there in the middle of the Supreme Court chamber.
He essentially surrendered the concept.
That is wild.
He conceded to the Chief Justice that CPR should no longer be used as a legal term or a policy directive.
Do we know why he backed down so suddenly?
Well, the sources contain a fascinating piece of documentary evidence that tries to explain this retreat. It's an affidavit executed by Executive Secretary Eduardo Ermita.
Okay, Eduardo Ermita.
Ermita, a high-ranking official, was basically tasked with explaining away the CPR press release.
How do you explain away changing the rules on the street?
In his sworn affidavit, he claimed that the phrase maximum tolerance, which was mandated by BP 880, had acquired a dangerous, distorted meaning over the decades since 1985.
Distorted how? How do you distort maximum tolerance?
Ermita argued that people on the ground, both the protesters pushing the boundaries and some police officers afraid of being reprimanded, mistakenly believed that maximum tolerance meant the police were legally obligated to endure absolute mayhem.
To just stand there and take it.
Exactly.
Wow.
He claimed the perception was that police had to stand down even in the face of serious threats to public order, absorbing abuse without taking any defensive or restorative action.
I see.
He further claimed that protesters felt they didn't even need to bother applying for permits because they knew their illegal, unpermitted rallies would just be passively tolerated by a handcuffed police force.
So Ermita is trying to thread a very tiny needle here.
He really is.
He is arguing that CPR was never actually a new law or a new set of rules. He claims it was just a tough-sounding semantic tool, a catchword designed to send a psychological message.
A warning.
Right. He wanted to signal to both the public and the police that the government would no longer be lax in enforcing the existing permit requirements of BP 880. He was trying to correct what he viewed as a dangerous, systemic misunderstanding of what tolerance legally meant.
That was his entire defense strategy. It was a matter of semantics, not a change in policy.
Did the court buy it?
The Supreme Court justices were absolutely not buying it.
I didn't think so.
The court delivered a sharp, decisive, and intellectually rigorous rebuke of the entire concept of CPR using a brilliant piece of inescapable legal logic.
Well, what's the logic?
The court set a trap. They reasoned.
Yeah.
If calibrated preemptive response means the exact same thing as maximum tolerance, if it's just a different word for the same procedure, then it serves absolutely no valid legal purpose.
That makes sense.
It only serves to confuse the public and the police, creating the exact chaos we saw on the streets.
Okay, that's the first half of the trap. What's the second half?
Here is the second half. But if CPR means something different than maximum tolerance, if it lowers the threshold for police intervention, if it allows for preemptive force before violence occurs, then it is entirely fundamentally illegal.
Why illegal?
Because maximum tolerance is the explicit, non-negotiable standard mandated by the national legislature in BP 880. The executive branch cannot unilaterally override a law passed by the legislature with a simple press release.
Wow, it is a flawless, logical checkmate.
It really is.
Either the policy is redundant, in which case it is useless, or it is different, in which case it is illegal.
Exactly.
Yeah.
The court left the government with absolutely no room for ambiguity.
And the language the court used to officially strike down the policy is incredibly powerful.
It's very memorable.
It is not dry bureaucratic jargon at all. Justice Azcuna, writing the decision for the court, stated that the so-called CPR policy has no place in our legal firmament and must be struck down as a darkness that shrouds freedom.
A darkness that shrouds freedom. When a Supreme Court justice uses poetry to condemn government overreach, it underscores exactly how sacred the court views the right to peaceable assembly.
Absolutely.
By striking down CPR with such emphatic, colorful language, the court firmly, undeniably reinstated maximum tolerance as the supreme, undisputed law of the land regarding crowd control.
So CPR is dead and buried. Maximum tolerance is the law.
Yes.
But this brings us right back to Executive Secretary Ermita's original fear, right?
What's your fear?
Well, if maximum tolerance does not mean standing idly by while people burn down a city block, what exactly does it mean? A phrase is just a phrase until it meets reality.
That's very true.
How is a police officer standing on the hot asphalt, sweating in a uniform, actually supposed to execute maximum tolerance during a chaotic, deafening protest?
Right. How do you operationalize that?
Exactly. This is where we have to open up the police playbook and examine the anatomy of maximum tolerance.
Let's do it. BP 880 defines maximum tolerance in Section 3, Paragraph C as the highest degree of restraint, that the military, police, and other peacekeeping authorities shall observe during a public assembly, or in the dispersal of the same.
Highest degree of restraint.
But the brilliance of the 1985 law is that it does not just leave that as a vague philosophical mandate for officers to interpret on the fly.
Thank goodness.
It operationalizes the concept with granular, incredibly strict physical rules. The architects of this law translated the philosophy of restraint into physical logistics.
Give me the mechanics. How does a law force a police officer to be restrained?
First, there is the 100-meter rule found in Section 9.
100 meters.
Yes. The law explicitly states that law enforcement agencies shall not interfere with the holding of a public assembly. If police are detailed to the area to ensure safety and manage traffic, they are legally mandated to be stationed at least 100 meters away from the area of activity.
100 meters. That is a full football field of distance.
It's a significant gap.
Let's think about the crowd psychology behind that specific measurement.
It's fascinating.
If you have a crowd of passionate, agitated protesters, and you place a line of riot police 10 feet away from them, you have instantly created a claustrophobic, antagonistic pressure cooker.
Just staring each other down.
Exactly. The mere proximity invites provocation from both sides. But by forcing the police to stand a full football field away, the law creates a massive physical and psychological release valve.
They're out of the immediate tension zone.
The police are there if a true riot breaks out, but they're too far away to physically intimidate the speakers or eavesdrop on the conversations.
It completely removes the immediate friction point. And the physical regulations go much deeper than just distance.
What else?
The law dictates a remarkably strict dress code of de-escalation for the police.
A dress code.
Yes. Section 10 paragraph mandates that officers dealing with demonstrators must be in complete uniform. And crucially, their nameplates, the units they belong to, must be displayed prominently on both the front and the dorsal parts, the back of their uniforms.
The architects of this law literally wrote a dress code into the statute to strip away the anonymity of the police.
That was the goal.
Because anonymity is what usually empowers riot police to use excessive force. If an officer is wearing a blank black uniform with a face shield, they feel untraceable.
They feel invisible.
Right. But if their name is plastered in large letters on their chest and their back, they know they are individually accountable for every single swing of their baton.
It is absolute accountability engineered through uniform design. And then comes the most critical restriction of all in Section 10, paragraph B.
Let me guess. Weapons.
Exactly. The members of the law enforcement contingent shall not carry any kind of firearms.
No guns at all.
None.
That is a massive systemic rule for de-escalation. If they are facing thousands of people and they cannot carry firearms, what exactly are they allowed to equip themselves with?
The law is very specific. They may be equipped with batons or riot sticks, shields, crash helmets with visors, gas masks, and boots or ankle-high shoes with shin guards.
Just the basics.
That is the entire approved inventory. It is entirely defensive, non-lethal gear designed to protect the officer, not to lethally suppress the crowd.
What about the heavier crowd control stuff?
Furthermore, Section 10, paragraph C, places severe restrictions on their broader arsenal. The deployment of tear gas, smoke grenades, water cannons, or any similar anti-riot devices is strictly prohibited.
Prohibited entirely, like a blanket ban on tear gas.
Prohibited unless, and this is the singular critical exception, unless the public assembly is attended by actual violence, serious threats of violence, or deliberate destruction of property.
So there has to be real destruction first.
Yes. Only when that threshold of actual or imminent physical destruction is crossed can those specific anti-riot devices be deployed.
Okay, let me pose a hypothetical scenario, because the real world is never as clean as a statute.
Sure, let's test it.
Let's say you have a massive, entirely peaceful crowd with a valid permit. Say 10,000 people gathered in a plaza listening to speeches perfectly following the rules.
A model assembly.
Right, but buried in that massive crowd are 5 troublemakers. 5 provocateurs who suddenly pull rocks out of their backpacks and start hurling them at the police line standing 100 meters away.
Okay, a localized breach of peace.
Does the presence of actual violence from those 5 individuals mean the police are now legally authorized to immediately fire tear gas into a crowd of 10,000 peaceful citizens and shut the entire permitted assembly down?
That is the exact nightmare scenario the law aims to prevent. And BP 880 actually anticipates it perfectly.
How?
This is where we look at the mechanics of Section 11, which outlines a highly specific mandated escalation ladder for dispersing a public assembly that has a permit but turns violent.
An escalation ladder.
Yes. The police cannot just jump from standing by to firing tear gas. They must climb a step-by-step process.
Walk me through it.
Step 1. At the very first sign of impending violence, the ranking police officer on the scene must call the attention of the recognized leaders or organizers of the rally and ask them to intervene and prevent the disturbance.
It gives the community the first chance to self-regulate.
Exactly. The law places the primary burden of policing the ranks on the organizers themselves.
But what if the organizers can't control the provocateurs and the rock throwing actually starts?
Then the police move to step 2 of the escalation ladder. If actual violence erupts and rocks or harmful objects are thrown at police officers, at non-participating civilians, or at property, the ranking officer must issue an audible warning to the participants.
They have to announce it.
Yes. They must clearly state that if the disturbance persists, the assembly will be dispersed.
An audible warning. They cannot just silently lock shields and move in. They have to communicate their intent to escalate.
Transparency is required at every step. And if the violence still persists after that first warning, they move to step 3. The ranking officer must issue a second audible warning. And then, and this is crucial for the concept of maximum tolerance, they must allow a reasonable period of time to lapse.
They have to wait.
They have to give the peaceful majority time to process the warning and clear the area safely. Only after that reasonable time has lapsed can the officer finally order the crowd to disperse.
And what about my hypothetical? The 5 rock throwers in a crowd of 10,000.
To directly answer your hypothetical, we have to look at a phenomenal safeguard in Section 11, paragraph E.
What does it say?
It explicitly, undeniably states, isolated acts or incidents of disorder or breach of the peace during the public assembly shall not constitute a ground for dispersal.
Wow.
Yeah.
That is an incredibly profound protective standard for the protesters. The law officially recognizes that a few bad actors or a few isolated hotheads should not possess the power to hijack and nullify the constitutional rights of thousands of peaceful citizens.
That's exactly right.
The police are legally obligated to extract or deal with the isolated individuals causing the breach, rather than collectively punishing the entire assembly by shutting it down.
It is a remarkably balanced piece of legislation on paper. It recognizes the volatility of crowds and penalizes both sides for violations to maintain equilibrium.
It seems to hold everyone accountable.
It does. Section 13 outlines the prohibited acts clearly. Yes, holding a rally without a required permit is absolutely prohibited and illegal. But, crucially, so is the arbitrary and unjustified denial of a permit by a mayor.
Both are crimes.
Yes. It is a criminal act for a police officer to violate the dress code and carry a firearm to a rally, just as it is a criminal act for a protester to carry a deadly weapon or a concealed firearm.
Are the penalties severe?
The penalties, outlined in Section 14, are not slaps on the wrist. They range from a month to 6 years of imprisonment, depending on the severity of the violation.
Okay, so, synthesizing all of this. The 1985 law seems incredibly protective of protesters. It mandates distance, strips police anonymity, bans firearms, and requires a slow, methodical escalation ladder before dispersal.
Assuming everything works as intended, it's a brilliant framework.
Right. But there's a massive, glaring catch to this entire system.
Always a catch.
All of these robust protections, all these escalation ladders, they all apply exclusively to an assembly that has a permit. Section 12 of the law says flat out that an assembly operating without a permit may be peacefully dispersed immediately.
So the permit is the shield.
Exactly. So the entire protective ecosystem relies on the fundamental assumption that mayors will actually process these permit applications fairly and efficiently.
Which is a big assumption.
What if a mayor simply ignores the applications? What if the local government just refuses to play the game, starving the citizens of the permits they need to be protected?
Well, the law actually had a built-in safety valve designed for this exact bureaucratic failure.
And this leads us to what I think is the most shocking, dramatic revelation of the entire Supreme Court case.
It truly is a stunning twist in the narrative of this law. To understand it, we have to introduce Section 15 of BP 880.
Let's hear it.
Remember the timeline. This law was enacted in October 1985. Section 15 carried a monumental mandate. It legally required that every single city and municipality in the entire country must establish or designate at least one suitable freedom park or mall within 6 months of the law taking effect.
A freedom park. What makes that specific plot of land different from any other park in the city?
The legal distinction is absolute. The law states that in these specifically designated freedom parks, demonstrations, meetings, and rallies may be held at any time without the need of any prior permit whatsoever.
Oh, wow.
This was the ultimate infallible safety valve engineered into the system.
So if the 5-day permit system was too slow for a break-in crisis, or if a politically motivated mayor was being arbitrary and denying applications, the citizens always had a guaranteed physical space in their city where they could exercise their constitutional rights immediately, legally, and freely, immune from dispersal.
Yeah.
That is a brilliant piece of urban planning tailored for a functional democracy. You mathematically mandate a physical release valve for public pressure in every single municipality.
It was a great idea. But here comes the revelation that stops the court in its tracks.
Let's have it.
We were in the Supreme Court chamber in 2006, evaluating the execution of this law from 1985. The justices ask about these safety valves. What happened to these mandatory freedom parks?
What did the government say?
During the intense oral arguments, the Solicitor General, standing before the highest magistrates of the land, was forced to make a stunning, embarrassing admission.
Oh, no.
20 years after BP 880 was passed by the legislature, 20 years after the strict 6-month deadline had expired, to his official knowledge, only one city in the entire Republic of the Philippines had complied with the law.
Let me stop you. Only one city. In 20 years.
Cebu City, which had faithfully designated Fuente Osmeña as their freedom park. But it gets significantly worse.
It could get worse.
When the justices specifically asked about the historical Freedom Park in the capital city of Manila, a place known as the Sunken Gardens, which had been a traditional bastion of free speech, the Solicitor General had to admit that the city government had not only failed to protect it, they had actively converted the Sunken Gardens into a golf course.
You have got to be kidding me. A golf course.
A golf course.
So what does this all mean? Let's process the absolute audacity of this situation.
It's hard to wrap your head around.
The government, in 2005, was actively sending heavily armed riot police into the streets, aggressively arresting citizens and breaking up rallies specifically because those citizens did not have permits.
Enforcing the strict side of the law.
Right. They were enforcing the punitive, restrictive side of the law with absolute brutal efficiency. But simultaneously, for 2 solid decades, the government had completely systematically failed to fulfill its own explicit legal obligation to build the permit-free parks.
The hypocrisy is staggering.
The very parks that made the whole permit system constitutionally balanced and fair in the first place had been ignored or literally paved over for a golf course. It is the height of bureaucratic hypocrisy.
The Supreme Court recognized the profound systemic injustice of this situation immediately. The court noted in their decision that without this required alternative forum, to deny a citizen a permit would in effect be to deny them their constitutional right entirely.
Because there's nowhere else to go.
Right. The state was trapping its citizens. And so, recognizing the failure of the bureaucracy, the court responded with an incredibly dramatic, aggressive, and creative judicial remedy.
Wait, the Supreme Court doesn't have an army or a construction crew. How do they fix a 20-year failure of urban planning?
They fix it with the power of constitutional interpretation.
Okay, how?
They cited the guiding judicial philosophy of Chief Justice Artemio Panganiban.
What was his philosophy?
Panganiban's philosophy stated clearly that in cases involving fundamental liberty, the scales of justice must weigh heavily against the government, and in favor of the weak, the marginalized, and the dissenting citizen.
So tie goes to the citizen.
More than that, laws that restrict fundamental rights come with a heavy presumption against their constitutional validity.
I see.
Driven by this aggressive philosophy of liberty, the court issued a strict, unyielding 30-day ultimatum to the entire national government.
A 30-day ticking clock. What were the exact terms of the ultimatum?
The court directly ordered the Secretary of the Interior and local governments to force compliance across every municipality in the country. They laid down a judicial decree.
What was the decree?
If a city or municipality does not officially designate a specific suitable freedom park within 30 days of the Supreme Court decision becoming final, then a massive automatic penalty kicks in against the local government.
A penalty? What kind of penalty?
If the 30 days expire, every single public park and plaza in that non-compliant city automatically, by operation of law, becomes a freedom park.
Wait, automatically? Every park?
Automatically and entirely. In any city that failed to meet the 30-day deadline, citizens would no longer need a prior permit of any kind to hold an assembly in any public park or plaza within the city limits.
Oh my gosh.
The entire permit system would be functionally suspended for those spaces. The only requirement left for the protesters would be to drop off a simple written notice to the police and the mayor's office, just so they could coordinate traffic, but absolutely no permission would be required and no denial could be issued.
Let me put an analogy to this because the sheer scale and audacity of this judicial ruling is wild.
It really is.
It is like a city council passing a law outlawing all street parking in the entire city, ostensibly to keep traffic flowing.
Sure.
But to make it fair to the residents, the council legally promises to build a massive free multi-story parking garage in the center of town within 6 months.
Okay, sounds like a deal.
Right. 20 years go by. The city hasn't laid a single brick for the promised parking garage. But their tow trucks are out every single day, aggressively towing cars off the street, slapping citizens with massive fines and saying, you broke the no parking rule.
Enforcing the penalty, ignoring the promise.
Exactly. And then the Supreme Court steps in, looks at the city council and says, you have 30 days to build that garage you promised 20 years ago. If you don't build it by day 30, then starting on day 31, the citizens of this town are legally allowed to park their cars right on the manicured front lawn of City Hall.
Yep.
They can park in the mayor's driveway, they can park in every public park in the city, and there is absolutely nothing you can do to tow them.
That is a brilliant, accurate way to frame the court's remedy. The Supreme Court weaponized the threat of absolute unregulated public access to force the sluggish bureaucracy to finally do its job.
Just brilliant.
The government was terrified of losing control of every park in the city, so the court used that fear to compel them to finally designate the specific, manageable freedom parks the law originally intended.
It was a masterstroke of judicial enforcement, turning the government's own negligence into the mechanism for ensuring the citizens' rights.
It really is a phenomenal piece of legal engineering.
It is. And as we start to synthesize all of this, pulling back from the details of the 1985 law and the 2006 Supreme Court ruling, I want to connect this directly back to you, the listener.
Always important to bring it home.
We have just spent an hour diving incredibly deep into the granular details of foreign jurisprudence from decades ago. We've talked about 100-meter police lines, the definition of a labor strike, and the conversion of a sunken garden into the golf course.
It's been quite a journey.
It has. So why should you, listening to this deep dive right now, care about BP 880 and Bayan versus Ermita?
You should care deeply because this case perfectly illuminates the universal hidden mechanics of a functional democracy.
The hidden mechanic.
Yes. In our daily lives, we so often talk about concepts like freedom of speech and the right to peaceably assemble as if they're just these lofty, pure, abstract philosophical ideals.
We take them for granted.
We casually quote the Constitution, we debate Enlightenment philosophy, and we assume the right just exists in the ether.
Right.
But what this source material proves is that guaranteeing free speech in the real world is actually an incredibly complex, gritty, logistical operation.
It's messy.
Very messy. It requires city planning. It involves complex traffic routing to protect both the marching citizen and the commuting citizen.
It involves mathematically calculating the exact distance a police line must stand to prevent crowd panic.
And defining the exact non-lethal protective gear an officer can wear to strip away the anonymity that leads to police brutality.
The soaring ideal of constitutional liberty has to be meticulously translated into the physical reality of hot asphalt, sweat, and unpredictable crowd dynamics.
Exactly. And it highlights a crucial lesson about vigilance.
What's the lesson?
It teaches us that we must be hyper-vigilant regarding procedural rules and bureaucratic systems. Governments do not always try to silence people by blatantly banning their message outright.
No, that is too obvious. It invites immediate backlash.
More often, the state attempts to suppress dissent by simply making the permit process so incredibly cumbersome, or by making the rules so confusing and contradictory, like the executive branch suddenly introducing calibrated preemptive response in the middle of the game, that the constitutional right becomes practically impossible or legally dangerous to actually exercise.
Exactly, the mechanism of subtle suppression the court sought to dismantle.
Yes, and the court's ruling on the presumption of permits is perhaps the most vital practical takeaway here regarding the burden of proof.
Remind me about that presumption.
The court definitively established that if protesters follow the rules, if they file their detailed application and the mayor simply ignores it for 2 days, the protesters do not have to go to court to beg for their right.
They don't need to sue the city?
No. They can just show up to the streets with their date-stamped application in hand.
And what happens then?
At that exact moment, the legal burden shifts entirely off the citizen and onto the state. It is suddenly up to the police and the mayor to scientifically prove, with clear and convincing evidence, that the application was legally denied.
Wow.
If the state cannot prove it, the police must step aside and the rally proceeds. It is a masterclass in holding government bureaucracy strictly accountable and ensuring that the default state of a democracy is freedom, not restriction.
That is powerful. So let's briefly recap the incredible journey we have taken today.
Let's do it.
We started with the violent, chaotic clashes on the streets of Manila in late 2005, a crisis driven by the confusing mid-game introduction of the Calibrated Preemptive Response policy.
The CPR mess.
Then we opened up the pages of the 1985 rulebook, BP 880, born in the twilight of the Marcos era, to understand the strict, logistically heavy permit system and the precise, physically de-escalating rules of maximum tolerance.
The 100-meter rule, the dress code, all of it.
We watched the Supreme Court mathematically trap the government, striking down CPR as a darkness that shrouds freedom.
A great quote.
And we witnessed the dramatic, aggressive 30-day ultimatum that finally forced a negligent government to build the freedom parks they had promised their citizens 20 years prior.
It is a complete, satisfying arc from street-level chaos to constitutional clarity.
It really is a profound historical reaffirmation that while the state absolutely possesses the power to regulate the physical time, place, and manner of speech to keep society functioning and traffic flowing,
the state can never, under any circumstances, use those logistical regulations as a bureaucratic shield to suppress the vital voices of its citizens.
Beautifully synthesized. But before we sign off, I want to leave you, the listener, with a final provocative thought to mull over. A question that takes everything we've learned and pushes it into the future.
Okay, I'm ready.
We have spent all this time discussing the intense physical regulation of public squares. We have been talking about literal asphalt streets, concrete bridges, and grassy parks. We analyzed the logistics of traffic congestion, emergency vehicle routing, and 100-meter physical police lines.
A physical world.
But today, in our modern era, the public square has largely migrated. It is no longer just physical, it has moved online.
Very true.
The public square is now hosted on massive, privately owned social media platforms. So how on earth do you apply these vital time, place, and manner regulations to the boundless internet?
That is a massive question.
Can a digital platform actually experience the equivalent of traffic congestion? If 1 million citizens tweet their outrage at the exact same moment, does it disrupt the flow of digital commerce or threaten public safety?
It's a whole new frontier.
And most importantly, if a government or perhaps a tech billionaire who owns the platform were legally required to designate a digital freedom park today.
A designated space on the internet where absolutely no algorithmic suppression, no shadow banning, and no prior restraint could ever exist.
Yes. What would that digital space even look like?
If the physical public square requires such delicate, granular balancing of rights and logistics to prevent chaos, the digital public square is a wild, unregulated frontier that we are only just beginning to map out.
It is definitely something to think about the next time you hit post or gather to share your voice. Thank you for joining us on this custom-tailored deep dive into the mechanics of democracy. Keep questioning the frameworks, both physical and digital, that govern your everyday rights. And we will see you next time.
Welcome to the debate. Usually when we think about constitutional rights, we imagine them existing in this, pure abstract vacuum.
Right. Like these pristine, noble ideals of free speech and peaceful assembly just hovering above us.
Exactly. We picture them completely unblemished by the messy physical realities of the world. But then you step out onto the streets of a bustling metropolis.
Oh yeah. You hit the asphalt, the heavy traffic, the complex flow of commerce.
Right, you've got ambulances trying to get to hospitals. A city is essentially a massive cardiovascular system. And suddenly, those abstract rights, they have to occupy physical space.
They do. And that's where the friction happens.
Precisely. When 10,000 people occupy an avenue to voice their grievances, that theoretical right physically collides with the daily lives of everyone else in that city. So today, we are examining that inherent tension, the tension between maintaining public order and protecting the fundamental right to peaceful assembly.
And, it is a tension that defines the operational reality of literally any democracy on Earth.
It really is. And we are anchoring this discussion today in a landmark 2006 Philippine Supreme Court consolidated decision.
Right, Bayan v. Ermita.
Yes, Bayan v. Ermita, and specifically the statutory text it analyzed, which is Batas Pambansa number 884, or as it's commonly known, the Public Assembly Act of 1985.
A very controversial piece of legislation.
Definitely. So the central question we are exploring is this: does requiring a government permit to hold a public assembly act as a reasonable, content-neutral regulation of time, place, and manner, or does it function as an unconstitutional prior restraint that arbitrarily curtails free speech?
It's a massive question.
It is. Now, I look at BSP 880 and I see a constitutionally sound framework. It is a mechanism strictly necessary to prevent grave public inconvenience, and I believe it manages to do that without stifling the actual speech of the citizens.
Well, and I look at that exact same framework and I see something entirely different. I mean, when you condition a fundamental constitutional right on prior government approval,
Right.
and when you explicitly authorize armed police to physically disperse unpermitted rallies, you are effectively transforming an inalienable human right into a mere administrative privilege.
Okay, I hear that. But to understand why the Supreme Court upheld the permit requirement, we have to look at the foundational logic of how rights operate in a shared physical space.
Sure.
We absolutely agree that the right to peaceably assemble is sacrosanct, right? It's the bedrock of a functional democratic polity. But a primary right is not an absolute right.
Meaning?
Meaning civil liberties inherently imply the existence of an organized society. Without order, liberty itself is just lost to chaos and unrestricted abuses. BP 880 does not ban public assemblies.
I mean, not explicitly, no.
Right. What it actually does is codify the clear and present danger test into a strict administrative process.
But we really need to unpack what that administrative process actually looks like on the ground.
Okay, let's do that. Because on the ground, prior to this law, local mayors could wield completely unfettered discretion.
Right. They were basically kings of their cities.
Exactly. They could deny a permit simply because they didn't like the political group asking for it. BP 88 strips mayors of that arbitrary power. It mandates that a permit must be granted unless the mayor can provide clear and convincing evidence of a grave threat.
A threat to public order, safety, or health, yeah?
Yes. And we aren't talking about a vague feeling of annoyance here. We are talking about verifiable proof that a rally will, for instance, block the only route to a level 1 trauma center.
Okay, but...
And wait, furthermore, the law contains this brilliant built-in safeguard. The mayor has exactly 2 working days to act on the application.
The automatic grant.
Right. If the mayor drags their feet or ignores it, the permit is automatically deemed granted. So the law is regulating the logistics of the city's cardiovascular system, like traffic flow, without ever judging the political content of the protester's message.
We really have to look at the actual mechanics of the law, though, because BP 880 establishes a strict no permit, no rally policy.
Well, a regulated rally policy.
But regardless of the 2-day automatic grant, the underlying reality is a de facto prohibition on spontaneous speech. In legal terms, we call this a prior restraint.
Which is a heavy term.
It is. And for anyone not steeped in constitutional law, that basically means the government is gagging you before you even open your mouth, rather than, punishing you after the fact if you actually incite a riot or destroy property.
But they aren't gagging the speech itself.
They are, practically speaking. Section 5 of the law requires organizers to file their applications at least 5 working days before the scheduled assembly.
Which gives the city time to reroute traffic and deploy emergency services.
But think about the psychological reality of a 5-day waiting period. I mean, it completely eliminates the possibility of spontaneous protests in reaction to rapidly developing events.
That is a fair point regarding spontaneity.
Right? If a gross government injustice occurs on a Monday, the public cannot legally take to the streets on a Tuesday to voice their outrage. The state literally forces them into a cooling-off period.
A logistical planning period.
A period where their political momentum is suffocated by a bureaucratic waiting room. And here is the truly dangerous part. Section 12 explicitly dictates that when a public assembly is held without a permit, that assembly may be peacefully dispersed.
Well, peacefully being the operative word there.
Yes, but the physical exercise of a constitutional right is being treated as an illegal act. It subjects citizens to police dispersal simply because they lack a piece of administrative paperwork. It shifts the entire dynamic of a democracy.
How so?
You are no longer a free citizen exercising a fundamental liberty. You are a petitioner begging the state for permission to complain about the state.
Look, I understand the visceral reaction to the phrase prior restraint, but I really think we need to be very precise about what the permit application actually entails.
Okay, let's look at the application.
If you look at Section 5, the application requirements are purely 100% logistical. The government just asks for the names of the organizers, the date, the time, the duration.
And the specific streets to be used, right?
Right. The streets, the probable number of participants, and whether you are bringing transport or heavy public address systems. What is glaringly absent from that list?
You're going to say the content of the speech.
A script. Yes, exactly. They do not ask for a script.
Well, they don't need a script if they can just deny the route.
But they can't deny the route based on the ideology of the group. None of these requirements ask for government approval of the political message. That is the very definition of a content-neutral law.
I disagree that it's entirely neutral.
But it is. It's strictly a time, place, and manner regulation. Think of it like a thermostat for the city. The mayor isn't evaluating the merits of the protest. The mayor is evaluating the physics of routing 10,000 people through a specific intersection at rush hour.
The traffic cop defense.
Yes, because if we don't regulate the where and when of a mass gathering, the sheer physics of a massive rally inherently tramples the equal rights of non-participants.
I mean, protests are meant to be disruptive.
To an extent, sure, but the right of a citizen to use a public road to get to their job or to travel home to their family is also a protected liberty. We don't let people indefinitely block a major bridge just because they have a righteous cause.
Okay.
The permit system is simply the neutral mechanism by which the state arbitrates competing legitimate uses of finite physical space.
So that bridge analogy is conceptually neat, but it relies on a massive underlying assumption.
Which is?
That the state is acting as a neutral traffic cop. The reality of enforcement tells a much darker story, and we don't even have to speak in hypotheticals here. Let's look at the specific phrasing of the law itself to see how this alleged content neutrality is actually an illusion.
An illusion? How so?
Look at Section 3. Which defines maximum tolerance. That is the statutory standard for the highest degree of restraint the police must observe during an assembly.
Right. It's a standard that protects the protesters.
But look at the psychology of the word tolerance. Tolerating an assembly implies a baseline of government disdain for the message being presented.
I think you're reading a bit too much into the semantics there.
No, think about it. You do not tolerate a parade celebrating the military or a massive festival sponsored by the state. You celebrate those. You tolerate a nuisance. You tolerate a grievance.
Well, yes, a protest is a grievance by definition.
Right, and the phrasing heavily skews the law's orientation toward policing anti-government protests, rather than universally regulating public space. The law uses words like protesting and influencing, which inherently suggests an exposition of a cause not espoused by the government.
I still think that's a semantic argument.
If the law were truly a blind administrative tool for traffic management, it wouldn't need to frame the exercise of a democratic right as something the police must grit their teeth and tolerate. It reveals an implicit bias.
I honestly think you are misinterpreting the target audience of the phrase maximum tolerance.
How so?
It is not a psychological assessment of how the government feels about the protesters. It is a strict operational directive given to armed law enforcement officers.
But it's still framed negatively.
It is a leash placed on the state's monopoly on violence, not a judgment on the citizen's right to speak. It is the law telling a police officer holding a riot shield, no matter what is being yelled at you, no matter how tense the situation gets, your legal mandate is to stand down and absorb it.
But again, that relies on the executive branch actually keeping that leash on the police. Let's move from the pristine text of the statute to the actual events that triggered the Supreme Court to step in with Bayan v. Ermita in the first place.
You're talking about the 2005 rallies.
Yes. In September and October of 2005, we saw massive multi-sectoral rallies attempting to march to Malacanang Palace and the Mendiola Bridge. How did the government arbitrate that physical space?
Well, they made a massive error in judgment.
That's an understatement. They didn't act as neutral traffic managers. The executive branch issued a press release announcing they were completely abandoning the statutory mandate of maximum tolerance.
Right.
They invented a brand new policy out of thin air, Calibrated Preemptive Response, or CPR.
Which became the absolute focal point of the entire Supreme Court consolidated decision.
Exactly. And we have to be very clear about what CPR actually meant on the asphalt. Under Calibrated Preemptive Response, the police didn't wait for violence. They didn't wait for a clear and present danger to manifest.
They were preemptive, hence the name.
Right. They actively blocked marchers along major thoroughfares. They preemptively and forcibly dispersed peaceful protesters, causing severe injuries and leading to mass arrests.
It was a very dark chapter, I agree.
And why did they do it? Because the protesters did not have a permit. This wasn't about rerouting ambulances. This was about silencing political dissent regarding policies that petitioners claimed put the country under undeclared martial law.
I see the connection you're drawing.
The very existence of the CPR policy in 2005 proves that when you give the executive branch the power to require a permit, you give them the perfect bureaucratic tool to invent rationales for preemptive violence. The permit requirement itself breeds authoritarian overreach.
Look, I completely understand the horror of what happened during those 2005 dispersals, but you're using the executive branch's direct violation of the law as an argument against the law itself?
Because the law enabled it.
No, the CPR policy was a rogue executive action. And how was it defeated? The Supreme Court utilized the exact text of BP 880 as the weapon to strike down that executive overreach.
Well,
the court explicitly declared Calibrated Preemptive Response null and void, precisely because it contravened the rigorous standards set by BP 880. The law was the shield that protected the citizens.
A shield that failed to protect the citizens from getting beaten on the streets of Manila before the court intervened. I mean, the chilling effect was already achieved.
But let's look at the mechanism of that shield. Because sections 9 and 10 of BP 880 engineer the physical environment to prevent that exact type of violence.
In theory.
In the statute. Why does Section 9 mandate that any police contingent must be stationed at least 100 meters away from the area of activity? Because the physical presence of riot shields inches away from a crowd's faces triggers an adrenaline response.
Sure, fight or flight.
Right, it triggers human fight or flight instincts. The law engineers a 100-meter physical buffer to de-escalate crowd psychology.
I'll grant that the buffer is a good idea.
And Section 10 requires officers to have their nameplates prominently displayed to strip away the anonymity that often leads to police brutality. It explicitly forbids them from carrying firearms. They are limited to batons, shields, and crash helmets.
Okay, but they still have batons and shields.
But most importantly, it dictates that tear gas and water cannons cannot be used unless the assembly is attended by actual violence. So when the executive branch attempted to initiate preemptive dispersals with CPR, the Supreme Court looked at BP 880 and said, no, the law says maximum tolerance. The law prohibits preemptive force.
Right.
You are criticizing the very framework that allowed the judiciary to definitively declare the executive's actions illegal.
Look, I acknowledge that the court striking down CPR was a massive victory for civil liberties, but you cannot separate the executive's overreach from the permit system that enabled it in the first place.
I don't see how the permit system caused the overreach.
Why were the police legally authorized to confront those protesters in 2005? Because the protesters didn't have a permit. The no permit, no rally rule provided the legal pretext for the police mobilization.
But that was an abuse of the rule. Section 12 states that an assembly held without a permit may be peacefully dispersed. The law tries to sanitize this by using the word peacefully, but come on. We both know that dispersing 10,000 passionate people from a public street is never a peaceful endeavor.
It is inherently tense, yes.
It involves physical coercion. By maintaining the 5-day permit requirement, the Supreme Court essentially preserved the government's primary bottleneck. They cured the symptom, which was the extreme police brutality of CPR, but they left the underlying disease completely intact.
The requirement for a permit.
Exactly. The requirement that citizens must ask for permission to speak, but that ignores a massive structural component of BP 880. The law already anticipates the exact scenario you are worried about. The scenario where citizens need an alternative channel for immediate, spontaneous expression without waiting 5 days. We haven't even talked about Section 15.
The freedom parks.
Yes, the freedom parks. Section 15 of BP 880 mandates that every single city and municipality in the country establish or designate at least one suitable freedom park or mall centrally located.
Right.
And in those spaces, demonstrations and meetings may be held at any time without the need of any prior permit. This entirely dismantles your argument that the law prohibits spontaneous assembly.
On paper, maybe.
No, legally, if a political scandal breaks on a Monday and the people must protest on a Tuesday, they do not need to wait 5 days. They do not need to file an application. They don't need to ask the mayor for anything.
They just go to the park.
They simply gather at the Freedom Park. This provision perfectly balances the need to keep major thoroughfares clear for commerce while preserving a dedicated, highly visible public forum for immediate democratic expression.
Well, Section 15 sounds like a wonderful, perfectly balanced compromise in a textbook. But the Supreme Court oral arguments for this case revealed a factual reality that exposes this so-called fail-safe as an absolute bureaucratic mirage.
Okay, let's look at the reality then.
Let's look at the timeline. BP 880 was passed in 1985. The text gave local governments 6 months to establish these freedom parks. During the oral arguments in 2006, 21 years later, the Solicitor General of the Philippines had to stand before the Supreme Court and admit that almost no one had complied.
Compliance was definitely an issue.
Out of the entire country, he noted that only Cebu City had properly designated a freedom park, which was Fuente Osmeña.
And, well, Manila had designated the Sunken Gardens.
Right. The Solicitor General mentions Manila designated the Sunken Gardens, and then he had to awkwardly admit to the justices that the Sunken Gardens had since been converted into a golf course.
Yeah, that is a glaring oversight.
It is absurd, but it is a profound illustration of how the state actually prioritizes space, elite recreation over working-class grievance. So you have 20 years of this law operating. 20 years of police strictly demanding permits. 20 years of police dispersing rallies under the guise of this balanced framework. And the alternative channel for unpermitted speech didn't even exist. It was a golf course.
I mean, that is undeniably frustrating.
You say the law provides a failsafe. I say the law provided a hollow promise. It allowed the government to strictly enforce the restrictive parts of the law, the permit requirements and the dispersals, while completely ignoring the liberating parts of the law. You cannot defend the constitutionality of a prior restraint by pointing to an alternative channel of communication that functionally, physically, does not exist.
I see the deep frustration there, and, the golf course anecdote is a stark reminder of bureaucratic failure. But I must push back firmly on your legal conclusion here.
How so?
What you are describing is a failure of local government compliance. It is not a constitutional defect in the text of the law itself. A law does not become unconstitutional simply because local mayors are derelict in executing one of its provisions.
But if the law has no teeth to enforce its own safeguards...
But it does have teeth. And this, right here, is where the absolute genius of the Supreme Court's 2006 decision shines. The court recognized this pathetic lack of compliance, but rather than throwing out the entire permit framework, which would have resulted in unregulated traffic chaos across the country, the court fashioned an ingenious self-executing remedy.
They created a judicial ultimatum.
Exactly. It's almost a rogue hack of the bureaucratic system. The court issued a mandamus, They gave local governments exactly 30 days from the finality of the decision to comply with Section 15.
Right.
And they added a brilliant catch. If a city or municipality failed to designate a specific freedom park within that 30-day window, the court ruled that all public parks and plazas in that municipality would legally default to freedom parks. Every single one.
It was a very clever legal maneuver.
Meaning no prior permit of whatever kind could be required to hold an assembly in any public park or plaza in that jurisdiction. The only requirement would be a simple written notice to the police, just to allow for basic coordination.
Right, just a heads up.
Exactly. By doing this, the court weaponized the government's own apathy against it. If the mayors didn't want to carve out one space for free speech, the court was going to give the citizens all of them. This proves that the legal framework of BP 880, when properly enforced by a vigilant judiciary, is a powerful engine for expanding civil liberties, not restricting them.
Look, I will grant you that the Supreme Court's 30-day mandate was an incredibly clever piece of judicial engineering aimed at forcing the state's hand.
It really was.
But it is a remedy that only proves my underlying point. For 2 decades, the state was perfectly happy to restrict speech without providing the promised alternatives.
True.
And even with all public parks defaulting to freedom parks, we are still left with the fundamental philosophical divide about how protests actually work. I mean, a park is a designated zone. It is safely out of the way.
That's the point, to balance the space.
But the nature of a protest is often to disrupt the status quo. It is designed to make the grievance impossible to ignore. A march down a major avenue forces society to physically confront an issue. A gathering in a designated park can easily be bypassed, ignored, and walled off by the very people the protesters are trying to reach.
That's a debate about tactics, though.
It's a debate about impact. By keeping the permit requirement intact for the streets, the state still retains the ultimate power to dictate the visibility, the volume, and the impact of the citizens' grievances. The court curbed the worst physical abuses, like CPR, sure.
Which was vital.
Yes, but leaving the 5-day permit requirement intact means citizens must still essentially ask the government for permission to complain about the government. The chilling effect on immediate, high-impact organic assembly remains untouched.
I think that perfectly frames the divide between our perspectives here. For me, Batas Pambansa 880, especially as interpreted by the Supreme Court in 2006, represents a triumph of democratic balancing.
A balancing act, yes.
It is a pragmatic framework that protects free expression while recognizing that the rights of non-protesters, the people who just need the cardiovascular system of the city to function, are equally valid.
Right.
It explicitly restrains police brutality by engineering physical buffers, codifying maximum tolerance, outlying firearms at protests, and demanding the clear and present danger test be met before any permit is denied. And through the Supreme Court's decisive 30-day hack, the law was ultimately weaponized to force the creation of permit-free freedom parks across the nation. It is a neutral tool for managing the complex logistics of modern democracy.
And my perspective remains that while the court successfully voided the dangerous calibrated preemptive response policy, it left the architecture of prior restraint standing. I mean, a right delayed is a right denied.
I hear that.
By maintaining a 5-day waiting period and authorizing the physical dispersal of unpermitted rallies, the law treats the fundamental right of assembly as an administrative nuisance to be managed. The golf course anecdote isn't just the funny piece of legal trivia, it is a profound illustration of the state's true priorities. BP 880 ensures that the government always controls the venue and the velocity of public dissent.
Well, while we clearly disagree on whether these administrative hurdles inherently violate constitutional freedoms, it is obvious we share a deep agreement on the vital danger of unchecked executive policies.
Absolutely.
The fact that the executive branch attempted to unilaterally replace the legal standard of maximum tolerance with preemptive physical force in 2005 is a chilly reminder of why vigilance is always required.
Indeed, the voiding of the CPR policy is a testament to the absolute necessity of pushing back against state overreach. The tension between civil liberties and public order will never be perfectly resolved. It is not a math equation. It requires constant renegotiation.
And that renegotiation happens every single time citizens take to the streets. We highly encourage you to reflect on this delicate balance as outlined in the Bayan versus Ermita decision.
And to explore the historical impact of the court's 30-day Freedom Park mandate in your own local municipalities.
Definitely. Think back to that metaphor of the physical street. Abstract rights are beautiful, but they must survive the friction of the asphalt. Thank you for joining us on this exploration of speech, space, and the law. We leave you with this question to ponder. If a right requires permission to be exercised, is it still a right, or has it become a privilege?